Welcome, everybody, to this podcast on regulating crisis in the EU. This podcast is a part of EmergEU, which is the Jean Monnet Center of Excellence on Crisis and Emergencies in European Integration. The Center of Excellence is embedded with the existing interdisciplinary Center for European Research in Maastricht, called CERIM. And this brings together scholars working on European studies within the faculties of law and the faculties of arts and social sciences at Maastricht University. In this podcast, we'll explore the legal dimensions of the EU's role as a crisis regulator. What do the EU treaties allow? What do they restrict? And how has this balance shaped the Union's response to the crisis of the past decades? My name is Esther Versluis, and I'm a professor of European Regulatory Governance at the Faculty of Arts and Social Sciences. And I will be recording this podcast together with Guido Bellenghi. Guido, welcome.
Thank you, Esther.
Maybe you would like to say a few words on who you are and what brings you here.
Yes, I am a Ph.D. researcher in EU law at the Faculty of Law of Maastricht University, and my research deals indeed with EU emergency law. And I guess we're going to discuss what this is in the upcoming podcast.
Yeah, perfect, Guido. I'm looking forward to that. And also here around the table is Elissaveta Radulova. Elissaveta?
Yes, hi everyone. I am associate professor at the Department of Political Science at the Faculty of Arts and Social Sciences. And I'm also course coordinator of the Regulating the EU, Regulating Crisis in the EU, I should say. And this is also a Jean Monnet module sponsored by the European Union. Otherwise, my background is in European public policy, so I'll be contributing with some questions coming from that direction.
Perfect. Well, I'm looking forward to this. This is, we hope that this is going to be interesting, particularly for legal students or law students who want to know a little bit more about the politics behind crisis regulation, and interesting for European studies students who want to know more about the legal implications of regulated crisis within the EU. But let's start with these legal foundations, the law in the books. Elissaveta, can you pose the first question?
Yes, sure. Thank you, Esther. As we all know, the European Union is a political construction, but it's, of course, based on law. And it's clear that when an international organization like the EU has to regulate crisis, it might be quite complicated to manage such crisis and to coordinate among so many member states. For the EU construction, the powers and the competences and the way crisis is managed is basically defined in the treaties, being a strong legal entity. And the key principle of governing EU competences is that the EU can only act to the extent that it has been granted such competences. And this is, of course, enshrined in the treaties. So it is interesting to understand how exactly the treaties define and organize the competencies when it comes to the EU capacity to act in times of crisis. And especially if you could clarify how does it work in different policy domains, because obviously the treaties endow the Union institutions to a different degree. So how is the EU then able to respond or not in such conditions?
Yes, so this is not of course an easy question, because we have a general system of competencies, and this system of competence is the system that then we have to use also when there's a crisis or an emergency. And I think that there's two elements that describe well the system of EU competencies. The first one is that these competencies, as you said, are attributed in advance to the EU in the treaties by the member states. So the last time competence were attributed to the EU was basically in Lisbon in 2007 when the treaty was signed. And the second element is that in the treaties, these competences are allocated along policy-specific lines, which means if you open the treaties, the books, you find different chapters and titles that refer to different policies, and for each of these policies, you will find specific provision telling you what the EU or the member states can do. So you have this double element, competences attributed in advance and policy specific. But then if you look at crisis and emergencies, these are typically either unpredicted or even unpredictable. And they are typically also transboundary, meaning that they touch upon different policy fields, they require complex policy packages to be addressed. So you have this double tension, right? On the one hand, competence attributed in advance to deal, however, with unpredictable circumstances, and on the other hand, also policy-specific policies to deal with very complex scenario in which different policy aspects and fields are touched.
Yeah. Can you give an example of such a transboundary crisis where you see this playing out?
Yes, absolutely. I think COVID is for us the obvious example, right? An health emergency that immediately deteriorate and escalate also in a major socioeconomic emergency. I think that's the easiest.
Yeah. And because of this tension that you described, you see that crisis situations really expose the gaps in the EU constitutional architecture, right? And can you elaborate a little bit more on what these gaps particularly are?
Well, I think that here also we have several aspects. It's impossible to mention them all, but a first one that I think is worth mentioning and stems directly from what we just said is this relationship between sectoral fragmentation and the complexity of crisis. So you have, of course, situations that are not straightforward, are not easy. Think of the Nord Stream pipeline. Of course, issues with the Nord Stream were issues related to the market, energy market, so internal market. You are within the EU law domain, but at the same time, there were issues of national security. So you are at the same time in a very, very core state function. Defense is another example. So the EU has helped the member states with the public procurement rules for defense equipment, has funded the defense policies of the member state, but there's no common European
Yeah.
defense. And health, since we mentioned COVID, is also another example. So the EU could and probably had to step in to do something, but there was always this limit that is clearly written in the treaties. Well, the EU cannot harmonize the health policies of the member states. So you have these differences. And I think another core issue is also the lack of autonomous enforcement powers. Of course, there are some exceptions, but we can generally and safely say that the EU does not have autonomous enforcement powers in the sense of monopoly of violence, use of force. Um, and I think to explain why this is relevant, we have to take the case of, for example, the so-called migration crisis. So 2015, sudden inflow of third country nationals and asylum seekers from the Middle East due to the geopolitical situation, and EU decides to adopt so-called emergency relocation decisions. So decisions according to which the member states were supposed to, let's say, redistribute these third country nationals. And some member states were outvoted when these decisions were taken because they were taken through majority voting. And these member states that had been outvoted decided simply not to implement the relocation decision. And the EU had no autonomous enforcement powers to step in, an EU police telling the member state, well, you have to do this. There were, of course, judicial proceeding afterwards, but it was not really in the moment where that was needed that you could step in.
Yeah. So lack of compliance by member states, there's nothing you can do.
Now, especially when you really need to urgently act.
Yeah, immediately on the spot, there's nothing. Yeah.
Yeah, I think just as a short follow up on the first very important feature you mentioned, the sectoral fragmentation, it's probably useful for our students just to remind that the treaties, which we always lump together, basically have these two components: the Treaty on the Functioning of the European Union, and there is where you see a lot of this different sectoral variation described and clarified in terms of exclusive or shared or coordinating and supporting competencies. So health would be there, while internal market will be shared, and that, of course, presents difficulties. And next to that, you have also the treaty on the European Union, and that's where, for example, security will be defined. So this is definitely a mosaic and a puzzle that is hard to navigate. But I want to turn to another question now, namely the EU emergency law. So we know from the national context, you have often in the constitutional provisions some form of state of emergency conditions or framework described there, and in a way um, anticipating on crisis situations. Is this the case also with the EU? Do we have this type of comparable set of provisions, and how do they look like?
So this is indeed exactly the topic of my PhD, and EU is a very special case. To answer directly to the point, well, there is no such thing as a general state of emergency or general emergency competence for the EU, like those that you would find in national constitution. We have instead a mixed picture. To understand this mixed picture, I think it's useful to briefly describe the three main models that we may have in emergency law, whether it is national law or international law. So we have a first model, which is the one that you would find in national constitutions, which is essentially we give emergency powers to public authorities, to normally executive, to deal with a certain emergency or crisis, regardless of whether it's a general or a specific power. And I would call this emergency legal basis. Then we have a second model that we find in international treaties and mostly international human rights treaties. And this is the model according to which the contracting parties, so that the states that are parties to that treaties, they can derogate from the obligations included in the treaties in the event of an emergency. And this is what I call the derogation clause. And a third model that we also find and that we have, for example, in a very famous Article 5 of the NATO, right, is the cooperation model. So the contracting parties of the treaties are bound to coordinate and cooperate in the event of an emergency. And this is what I call the cooperation clause. And what is interesting about EU emergency law is that basically you find all these three models reflected. So in the EU treaties, you find emergency legal bases that give the power to EU institutions to act and react to an emergency. You find derogation clauses that give the member states the power to derogate from EU law in the event of an emergency. And you find cooperation clauses that essentially mandate the cooperation either between the member states or even between the member states and the Union in the event, for example, of a natural disaster or a terrorist attack. Now, I think that there are also certain common elements among these clauses, and the first one I think is the fact that the member states are always in charge, but they are still bound to EU law, so they act within an EU legal framework.
So could we say, listening to you, that it is really up to member states to what extent and how these emergency laws or clauses are actually used in practice?
I would say yes. I would say that's a correct statement, because when you look at the emergency legal basis, so when it's the EU that is acting, that is always or almost always the Council, which means it's a very intergovernmental
Yeah.
setting. When you look at the derogation clauses, it's of course the member states that are derogating with their emergency measures, and then of course there's control exercised by normally the European Commission or the Court of Justice. And when you look at the cooperation clauses, is once again the member states normally that have to coordinate and cooperate. Although, of course, this normally happens within the context of EU centralized platforms or frameworks.
Indeed. But I want to ask so many questions about this, but this basically already brings us to the second core topic that we wanted to discuss, and my questions also relate to that. So we now talked about the law in the books, if you will. What is the treaty base? What is this emergency law? But how does this now actually play out in practice, right? So EU is bound by legal constraints, as we just discussed, but when we look at the reality of a crisis that maybe just happened, what really happens in practice? To get back to make the link to what we just discussed, with member states really also needing to be actively in the driving seat. Is this then is it enough that it's some member states that take the lead, or does this really require unanimity, or is this also very much crisis dependent? Is the Commission sometimes in the driving seat for getting emergency law enacted? Guido, enlighten us a little bit. What do you know? What examples can you share in terms of how does the law really play out in practice here?
Well, this is the $1,000,000 question in the sense that it is very difficult, I would say, to trace and to find a universal answer
Yeah.
to this question.
I was worried already that would be the case.
And indeed, it is of course the answer is of course crisis dependent. So in different crises and emergencies, we've had different solutions. But I think maybe a way to approach this is simply empirically looking at what has been done.
Mhm.
And I think that a great example in this sense that connects a bit the law and the practice is looking at one specific provision in the treaties, which is Article 122 TFU. This was a provision that basically we were not even aware of before Lisbon, so a provision that had rarely been used. And then as of the financial crisis, we've seen the rise of this provision used to underpin so many different emergency responses and so many different emergency measures. So one provision of the treaties was enough to, in 2010, create European financial stability mechanism. So the facility through which the EU granted money to member states that were struggling during the financial crisis. And then the same instrument was used in 2016 to provide financial support to the member states that were struggling with the problems with the asylum system, due to the geopolitical situation in the Middle East. And then again, financial assistance through this instrument was given after COVID, so Next Generation EU, but also now to the member states to arm themselves through the Rearm EU plan. So you would think this is a financial assistance instrument, but then you look at it, and what you find is that this same provision, this emergency provision, was used also during COVID-19 for the procurement of vaccines,
Interesting.
for the fight against unemployment. After the Russian invasion of Ukraine, this provision was used to set price caps on energies to facilitate the procurement of weapons at the moment. This is how this provision is being used.
And this is always this Article 122.
Yes, it's always this Article 122 that comes into play and signals something that is, I would say, a clear element of emergency law in practice, which is creativity, legal creativity. So you take your tools, your legal tools, and then you reinterpret them, you stretch them. So this 122 TFU, as I said, was barely used, then was used for financial assistance. And then now we've reached a point in which the Commission and the Council have used it to create essentially a tax, an excessive tax profit on those companies that benefited excessively of the increase in the price of energy. So a lot of creativity, both for tools that are originally meant for emergencies, but also for ordinary tools. So tools, legal instruments that are not even originally thought for emergencies, but then during emergencies are reinterpreted.
Yeah. And who would you say is then the architect behind this creativity?
This is a very very interesting question, and I guess we'll never have a final answer. But I would say that the main architects are actually the legal services of the institutions, and in particular the legal service of the European Commission and
Yeah.
the legal service of the Council. So
Yeah.
these people are really those that sit down and have an objective, a political objective that is given to them, and then they have to find a way to make it legally feasible, and they really are, in a way that they are artists with the law and what they do.
And how does this then relate to the important role that member states also play? Because we just concluded it's also, member states need to enact a certain instrument. So can you fine tune how does this balancing act work? No, let me phrase it differently. Can these legal architects be creative without support of the member states? Or
What
do
are
they
the limits, basically?
indeed?
What are the limits of this creativity?
I think that the interesting bit is that the input for this creativity comes from the member states. So what we normally see is that politically at the level of the European Council, there's an agreement to adopt certain measures quite urgently, and essentially the Commission is delegated and is instructed to come up with a proposal to find the solution that the European Council has identified to make it legally feasible. So we have an original input that essentially comes from the member state that goes through the Commission and essentially the legal service of the Commission for the legal fine-tuning. And then the proposal of the Commission, of course, ends up in the Council, but as long as the Commission has, let's say, respected the more or less detailed instructions that were given, by the European Council, that is just, let's say, a final rubber stamp on the proposal that is, of course, put again by the member states in the Council.
That's a very nice illustration of the intertwinement of politics and law, I would say. It made me think of the migration crisis in 2015, where it was basically exposing the gaps in the Frontex regulation and the way Europe is able to deal with the crisis. And I think back then there was a deadline from the European Council by the 1st of June of 2016. Please revise and offer a brand new organization of those competencies of Frontex. And eventually it happened. And it was exactly this type of intertwinement of political assignment, creative technocrat and legal artists, as you said, and then eventually letting it through the institutions.
Yes, of course, this is a strength of the system, but also a weakness in a way, because then, the treaties also say that the Commission is the one that has the initiative, right? So when you have this crisis and emergency scenarios, then the European Council steps in. But when the instruction that it gives to the Commission are too detailed, the question arises, okay, is the European Council becoming the real initiator of legislation? And this is not supposed to be. So yeah, it's a delicate balance to strike.
Are there any other negative externalities you think of how this plays out in practice, this interplay between politics and law in that sense?
I would say there are many. One that I think is perhaps more evident and more also pressing, I would say, is the level of democratic legitimacy that these emergency responses have, in the sense that the European Parliament is clearly marginalized in these emergency responses, is always simply left out. And the European Parliament itself is clearly not happy with this, so has proposed several reforms and has even now challenged the Council before the Court of Justice. So there is a pending case in which essentially the European Parliament is saying that for this Rearm EU plan, the use of emergency measures was not justified because the Council could have opted for other laws, ordinary laws, that would indeed entail a role for the European Parliament. So the question is, especially when these emergency measures, such as in the case of Rearm EU, are ultimately designed to reach broad policy shifts, so we invest our public money in rearming, in defense capacity, regardless of whether that is a good or bad choice, should the Parliament have a say about that?
Yeah.
And of course,
So it's basically the question, was this really a crisis that was being tackled with this particular proposal?
indeed, that is something that we will see how the court addresses. But in general, the court tends to be quite differential, so to leave quite some margin, quite some discretion to political institutions when it comes to crises and emergencies. And this is not only the Court of Justice, it's any court in the world. So I'm not expecting major, let's say, findings or revolutions from the Court of Justice.
So you expect them to not agree with the European Parliament here?
I cannot say for sure, but I would be surprised if they reach any decision in which they clearly limit the discretion of the Council. So I'm inclined to see what the Council has been doing, as, let's say, within the boundaries of its broad expression.
And is this also a consequence of it not being very explicitly defined what a crisis or emergency actually is, and that you need this discretion in order to have the flexibility that one needs to deal with such unexpected circumstances?
Yes, for sure. There's a problem of vagueness, of broadness of definitions, and this comes from, the stratification of these multiple treaty layers through the Treaty of Rome and then Maastricht and Amsterdam, Nice, and Lisbon, in which these emergency provisions were not really so central, so well developed. And now, when I mentioned the example of 122 TFU, we realized that we are working with an instrument that was actually designed in a different world,
Indeed.
in a complete different context. And
Also not with this in mind, right?
No, definitely.
Yeah.
But that's always what politics basically does with circumstances. It constructs them in a way so that urgency is raised, or on the contrary, tamed, and eventually the institutions react in one way or another using legal provisions in a very creative way. We saw this also in the context of the member states to a very great degree. And then again, the same issue of democratic control over these measures that were adopted came up. And usually it just went through.
Yes, this is also with the paradox of the EU treaties. On the one hand, they are constitutions, so it's very difficult also to change them because you need unanimity and all the member states coming together. So they're quite rigid. And at the same time, they're also pretty detailed to be a constitution. So we are working in a framework which is, let's say, flexible to be a constitution, but not very flexible because it still is a constitution. So yeah, this is a bit the paradox we need in as EU lawyers, let's say.
Well, maybe that brings us nicely to the last topic we want to discuss with you, Guido. What do we make of this now when we look forward? What lessons for the future can actually be drawn based on how the EU has been handling these post-crisis situations? You've clearly discussed some of the potential negative externalities related to how things are related currently. Has the EU adopted its legal provisions in order to navigate crisis? Could they have done it more efficiently? Would changes potentially be required in terms of how to better handle crisis situations in the future? What would your take on this be based on your own research also?
I think that a clear take is that the EU learns from crisis in the sense that most of these relatively recent, of let's say that most of the crises and emergencies that have happened over the past 20, 30 years have led ultimately to permanent change in the legal framework. So adaptation and improvement to a certain extent of the legal framework. I think that the first clear example is the BSE crisis. So basically the mad cow crisis in the 90s. There was a huge panic because of the uncertainty surrounding.
Maybe you want to explain this in 2 sentences because I think many of our students were not born yet.
No. So well, essentially there was a disease that spread in the meat,
Livestock.
in the livestock, in beef, essentially, especially in the UK, and there was a huge uncertainty surrounding the issue whether this disease could be transmitted to humans. So a massive emergency that required essentially banning the import of beef from the UK by the Commission. But to cut the long story short, what that situation told us in the end, because there were committees of inquiry afterwards and so on, was that the EU was massively unprepared to deal with such an issue in internal markets,
Indeed.
also as
Yeah.
an epidemic, let's say, and after the BSE crisis was over, the entire system of food safety was revolutionized, and now we have centralized crisis management.
We even have a special agency to take care of that.
Indeed, EFSA that does that now. So we have a new framework. Or you mentioned Frontex before. Of course, after the migration crisis, there was this, and I don't love the term migration crisis, but let's say this is how it is. It has been branded. There was a realization that we needed more enforcement powers for Frontex, and those powers were given on a permanent basis. Or joint procurement. I mean, in COVID, it was clear that we needed new procurement strategies for medical devices and vaccines, and now joint procurement is an ordinary mode of governance. Same goes for the Commission going on the markets and borrowing money. This was something that, I mean, had happened so far only in pure crisis emergency context, but the use that has been done in crisis and emergency context is bringing us to develop something that is way closer to a common fiscal policy. So there's change that comes from crisis and emergencies. This is, I think, good in terms of resilience and capacity to adapt. It is also, of course, it poses some question, let's say, because sometimes measures that are, let's say, underpinned by reduced democratic legitimacy because they're meant to be emergency measures, then they are somehow, they sip in the ordinary legal framework, and not necessarily this passage occurs through the necessary, let's say, democratic.
Indeed. Yeah, and then we come back to the question of legitimacy.
Yeah. So you basically don't preview change in the treaties. It's rather going to be this patchwork of adaptation following concrete event, concrete crisis. And then the question, of course, arises: shouldn't it in the legal circles? Perhaps you can tell us how legal scholars think about it. Should this patchwork of emergency adaptations continue, or do we want some kind of legal certainty installed?
Well, I believe there's two layers to the answer. So the first layer must be necessarily that I don't think anyone sees any treaty change coming any soon. So that's
I don't think there's any political will. No.
so that already renders the let's say this question quite hypothetical. And I've dealt with the question myself, and many people have tried to analyze it from both a more political or a more legal perspective. And I think that in any case, to get closer to what a state does, so to have a general emergency competence for the EU, which is what has been proposed, for example, by the European Parliament, is something that would beforehand require a massive rethinking of what the EU is, because of the um, way in which we have described the system of EU competences, which has been working in this way for 70, 80 years, I don't know. Uh, to have something like a general unspecific competence for any emergency scenario would mean first rethinking entirely what the EU is and how the EU works. So I do not think this is something that we can expect in the short term, nor do I think that this is something that should be taken lightly.
Yeah.
Well, many thanks, Guido. This was very enlightening. Maybe as a very last question, particularly for our students. In the course Regulating Crisis in the EU, in the Bachelor European Studies, students are basically asked to analyze a crisis of their own choice. And they particularly need to, well, first of all, better grasp the crisis, but also provide a policy recommendation in the end on how to actually advise the Commission on better tackling the crisis. Would you, from your perspective and your research that you've done, have any advice for our students in terms of what to search for, where to go for, questions to ask? What comes to your mind?
Maybe indeed I do have one suggestion, because there is a method that I apply in my research, and whenever I must to discuss this or comment about emergencies or specific measures. And I think that there are four key questions that one should always ask when looking at an emergency or a crisis and the measures that have been adopted. So the first one is, well, what is an emergency? So if we look at the law, does this qualify as an emergency? Do we have conceptual or terminological issues with defining this situation as an emergency? The second question, I think, is the institutional arrangement. So the way in which the various actors acted during the emergency. So who was in the driving seat? Who took the measure? What was the procedure that was used? Where all interests represented? Um, the third question is more concrete, and is what was done? What was the content of the emergency measure? So um, was there a derogation from the normal division of competences? So was something more or something less done? Were there limitations imposed on individual fundamental rights, for example? Were the measures actually generally temporary and proportionate, as emergency measures should be? And the final question is always, were there sufficient safeguards in place? So was there a role for courts? So were courts called to review the measures? Was there some level of parliamentary scrutiny? And this is very important because it avoids what has been called the crisification of policy, or the instauration of a permanent state of emergency. I mean, we need some safety net, some control to prevent emergency from becoming normalcy.
Indeed. And that leads to potential dangerous situation, particularly when you, for example, have populist parties in government
Mhm.
aiming to crisify everything that can be labeled as a crisis.
This is actually how our module starts, with opening up with the question, what constitutes a crisis? And who constructs it as a crisis, and who argues for it? And thank you very much for this roadmap of procedures or steps in your analysis, because that's pretty much also what we are guiding our students through in our Jean Monnet module. So thanks a lot.
Yes, also on my behalf, thanks a lot, Guido. This was very insightful.
Thank you very much.
Okay, well, thanks for listening. And should you have further questions, feel free to reach out to your tutors. And if you have very specific questions on the legal side for Guido, I'm sure he will be able to answer to your emails.
Absolutely.
Okay, perfect. Thanks.
Thank you.